Well, I still want you to prove on the record that you have subject matter jurisdiction, personal jurisdiction.
I'm not proving anything on the record, sir. I wear the robe. They put me in this position. I've been here 10 years. If I didn't have subject matter jurisdiction, I wouldn't be here.
So you say it's not a difference between public and private for the record? There's no difference.
Sir. Right. And Mr. Bay/Brown, you've indicated that you wish to have an attorney, so I'm going to rely on the fact that you're going to have an attorney. Don't come back here with the same stuff, and I already told you it's not going to work. Mr. Bay, do you have an attorney representing you, sir?
Attorney General, my Attorney General is online. You may speak to me, sir.
Is the Attorney General, Mr. Bay, hold on. Let me ask my question before you tell me something crazy. Is the Attorney General a member of the State Bar of Georgia?
I'm a non-state actor. I'm a foreign national.
We're here. What is going to end up happening is an attorney from managed assigned counsel is going to come down. Do you understand?
I do not understand because I don't feel like I am needing an attorney because I'm here to represent myself as the flesh and breathing man, Hector. This Constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under
all right, I'm going to counsel. I'm sorry, Mr. Casanova. In the human flesh. I'm going to stop you right there. What is going to end up happening? I want you to hear me clearly.
Welcome back for a classic duo of sovereign showdowns featuring two of YouTube's most popular judges. First up, we're in Judge Hayward's courtroom in Clayton County, Georgia, where we meet Marcus Brown. Well, he'd prefer to be called Marcus Bay for some odd reason. In this two-part saga, Marcus first appears as a somewhat reserved defendant, listening to Judge Hayward's instructions without too much pushback. But when he returns for round 2 with his sovereign homeboy acting as his pseudo-counsel, he comes back with a much different attitude and a head full of bold SovCit nonsense. Will Judge Hayward entertain this duo's antics and allow his unqualified attorney to keep steering him in the wrong direction? Or will she swiftly send them both packing with their tails between their legs? Then we move over to Texas, where Judge Boyd takes the bench with a rookie sovereign defendant who's trying to stay polite despite his shaky understanding of his own script. Thankfully, Judge Boyd is as patient as ever, willing to guide this uncertain SovCitiate through his misguided arguments with her trademark grace. Will this polite yet perplexed defendant be able to muster up some confidence? Or will Judge Boyd's calm and steady approach put his argument to rest once and for all? Stay tuned to find out.
Brown.
Your Honor, we were representing him, but we are going to be submitting a withdrawal to you. You should have it shortly.
All right. Mr. Brown, are you represented by somebody else?
Yeah. For the record, I am DeMarcus Bay, the implied surety for DeMarcus Contrell Brown. And I would like to file a motion in the court for additional 30 days for me to seek counsel.
Moments later.
Okay, so Mr. Bay, yes. AKA Marcus Contrell Brown, so you're seeking a continuance to get new counsel?
Yes.
Okay, do you have someone in mind, sir?
Not right now. I'm seeking counsel.
Okay, so here's the thing. I'm going to give you a continuance for 30 days, or I'm sorry, until January 5th. But by that time, you need to have counsel on board when they come back so that they can talk to the state to determine if there's anything they can work out on your case, or if they need to get all of the information necessary for a trial, if that's what you choose to do. So by January 5th, I will expect that you will have counsel.
Well, I have paperwork on the docket that haven't been rebutted. I have affidavits of truth that haven't been rebutted.
Okay, sir, we don't do affidavits. People have to appear in person because there's a confrontation clause in the United States Constitution that says witnesses, you have the right to confront witnesses in person. So we don't do affidavits, okay? If you have witnesses that are going to present testimony or evidence on your behalf, then you have to have them come to court and be sworn in and testify at that time, okay? So we're not doing any dismissing and all of that stuff. No, sir. When you get your counsel, they'll be able to discuss it with the state, and then y'all can present whatever to the court.
And the accusing deputy must be present too, okay?
So the people always say that, but here's the thing. The state gets to choose whatever witnesses they wish to bring, just like your side gets to choose whatever witnesses you wish to bring. You can't rely on them to bring the person that you want. So if you want to subpoena someone to appear for trial, then you need to subpoena them. You cannot rely on the state to bring your witness. Okay?
Okay. I got you. So,
all right. Anything else?
And jurisdiction can be challenged at any time, right?
No, sir. Jurisdiction rests with this court because this is where the locus of the incident is.
Well,
Mr. Bay, let me just explain something. Mr. Bay, listen to me.
Okay.
I went to school for 3 years for this. That's full time. If I had gone part time, it would have been 4 or 5 years. And I have been working since, oh Lord, I ain't gonna give my age, but I've been a lawyer and a judge for quite some time. I've been a judge for 10 years as of this year. A lot of times people come before me because they've learned stuff from other people, or they've gone online, or they've read it themselves. But I tell you, it doesn't work the way you think it works. And so there's a set of statutes, cases, procedures, all of those things that we have to learn. In fact, let me show you something.
Well, how do you have...
Wait. You see this book right here?
Uh-huh.
This is just this year's edition of all the stuff that I have to be able to find to figure out what's going on in your case. This is just this year's edition. And I got a book like this that includes evidence and procedure. I got a whole wall of books. So when you come in here challenging jurisdiction and all of this stuff people have taught you, it's not
books. Can I show you my Black Law Dictionary?
No, sir. Because Black's Law, that's a dictionary. That's not the full case. You know, you come in with all of these ideas about how you think the law works, but every lawyer in here has done at least 3 years of law school and trainings, trials, all of those things. So you're not going to change the way we do things. So the best thing to do is to get an attorney who can talk to the state about your case, and then we can get this resolved. Your case is pretty simple. You got traffic offenses.
Well, I still want you to prove on the record that you have subject matter jurisdiction, personal jurisdiction.
I'm not proving anything on the record, sir. I wear the robe. They put me in this position. I've been here 10 years. If I didn't have subject matter jurisdiction, I wouldn't be here.
So you said it's not a difference between public and private for the record. There's no difference.
Sir, get an attorney.
Okay, all right.
Yes, sir.
Okay.
And Mr. Bay/Brown, you've indicated that you wish to have an attorney, so I'm going to rely on the fact that you're going to have an attorney. Don't come back here with the same stuff, and I already told you it's not going to work.
So you're telling me United States codes don't work?
No, I'm telling you, you don't know them. So
I have it right here.
The United States codes don't work in Georgia because Georgia has its own code, OCGA.
So the meaning of driver is different in Georgia.
Yes, sir.
But according to 49.
Mr. Bay, I'm not doing this with you. Get an attorney. Okay. Thank you, sir. You're free to go. We'll see you on January 5th at 10.
3 weeks later.
DeMarcus Contrell Brown.
I have interest in that matter. Is the defendant in error free to go?
Is the who, what?
Is the defendant in error free to go?
No.
Well, let the record show the defendant in error is ordered to stay and participate.
Okay, who is the defendant in error? That's a new one for me.
The all cap name is trust that I am a beneficiary of. My name is not spelled in all capital letters. I have a court order decree saying that.
Okay, Mr. Bay. Mr. Bay, do you have an attorney representing you, sir?
Attorney General. My attorney general is online. You may speak to me, sir.
Is the attorney general, Mr. Bay, hold on. Let me ask my question before you tell me something crazy. Is the attorney general a member of the State Bar of Georgia?
I'm a non-state actor. I'm a foreign national. Matter of fact, I filed
Mr. Bay.
oath of office.
Mr. Bay, I don't care if you were Alexander Putin, the premier of Russia. If you are in Georgia and you're represented by an attorney, that attorney would have to be a member of the State Bar of Georgia. Foreign national or not. Just as if you went to another country and you had an attorney represent you, that attorney would have to meet the requirements of that country and of that state. Okay, Mr. Attorney, Mr. Bay, hush. Mr. Attorney General,
I'm trying to set a record.
Mr. Bay, Mr. Attorney General, are you a member of the State Bar of Georgia? You want to unmute for me?
Speak, bro. Get off me.
What's going on is he's a member of a foreign state corporation, basically doing business in Georgia.
Why? This is business. This is my sweat. I know, but I did business. Shut up! Shut up!
So
okay,
basically,
sir, that's not what I asked you. No, sir.
I get what you're saying, man.
No, and I get what you're saying, but we're not doing that because that's not how we operate. Those are not the laws under which I am required to conduct court. So we're either gonna do it my way or we're gonna put you on the calendar.
We understand the rules of the court. I got you.
Okay. Are you a member of the State Bar of Georgia?
No, I'm not a member of the Bar of Georgia.
Okay,
what I'm trying to realize
as he can represent himself,
you need to take consideration on that matter on how he's doing business in Georgia.
This is business. Hey. I invested the money. Stop talking. I will kill you. Sorry, sir. Hey, Dada. Why? Business.
He can represent himself, or he can be represented by a member of the State Bar of Georgia, but he cannot have you represent him or purport to represent him. Okay? Okay? That's not going to work. All right. So, Mr. Bay, do you wish to choose someone who is a member of the State Bar of Georgia to represent you, or do you wish to represent yourself?
I invoke my right to remain silent as the beneficiary of Demarcus Cottrell Brown estate.
Okay, sir. So, sir, you're invoking your right to remain silent, which means that you do not wish to enter a plea that
I plead to be released.
That would resolve your case today. As such, the court is going to enter a plea of not guilty for you.
I object. You cannot practice law from the bench. Violation 28 U.S.C. 454. Judge practicing law from the bench.
And put you on a trial court, on a trial calendar so that your case may be heard at trial.
I object.
All right, sir. Thank you. You'll get notice in the mail if anything changes about your changes about your address. Then you can go ahead and let us know by coming in.
I demand evidence hearing.
You will have that at the time of
the trial. Evidence hearing.
You're not going to have an evidence hearing today because that's not what we're here for. This is
you are dishonorable. I got your oath, Tammy Long. Hey.
So, Mr. Bay, I'm going to enter a plea of not guilty on your behalf. You'll have a trial at which time you can have an evidence hearing. You'll get notice in the mail.
You're in violation of Article 6, Section 2 of the Constitution.
Your notice in the mail, then you can appear for hearing with whatever evidence that you wish to present. You are not required to present any evidence or testimony because the state has the burden of proving the case against you. Thank you, Mr. Brown. You're free to go.
Mr. Casanova, you want to come forward? Yes. Hello, how's it going?
It'll be better.
All right, so my understanding you want to represent yourself? All right, you're more than welcome to represent yourself, but here's the thing. Everybody says that they can be an attorney because all attorneys do is talk. That's what people think. But they don't realize there's a lot of knowledge, experience, and wisdom behind that.
Absolutely.
So if you want to have a jury trial where you represent yourself, you're more than welcome to do so. But once it's set for trial, it's going to trial, and no one's going to be helping you. The state is not going to say, hey, we see that you really don't know the rules, so let me tell you this rule. They're not going to be doing that. My job is not going to be to help you with objections, help you with motions. That's 100% you. Do you understand?
I do. And so are we on the record?
No, we're not on the record. What, you want to put something on the record?
Oh, yes, definitely.
Sure. All right, court is calling 2024 CR 2974, State of Texas versus Hector Casanova. Can I have parties announced for the record for the state? And are you Hector Casanova?
No, for the record, I am the flesh and breathing man. I'm here on a special appearance to clarify any misunderstanding. I am not the legal fiction known as Hector J. Casanova that is on the information there. I just have a few questions to clarify some things.
All right, so if you would like to clarify some things, then the person I need to speak to is the flesh and blood man known as Hector Casanova.
Yes, I'm the flesh and blood man, Hector Casanova Jr.
All right, so you are Hector Casanova, correct?
I am Hector Casanova Jr., the flesh and breathing man.
All right, well, I'm glad you're breathing. So what did you want to place on the record?
Well, first, I don't understand the charges that are being brought against me. There are some clarifications I do want to.
All right, so just 1 second, but before we get to that, have you been given a copy of the indictment?
No, I have not.
All right, so we're going to get you a copy of the indictment. Just give me a moment. All right, have a seat. We're going to come back on the record with this.
All right.
Casanova, here's the thing, and I want you to hear me clearly. Right? I am not your attorney. The document that has been given you is a copy of the indictment. I'm not to give you information about your indictment. That's the indictment. That's what we're here for. So any questions that you would have about that indictment, you're going to have to answer those for yourself. Otherwise, the person who will be telling you about what the indictment means and what the numbers are, that will be an attorney. Do you understand?
I do not understand.
Oh, what that means is, for example, we can go off the record. I'm giving you a hypothetical. All right. Let's say you needed surgery and you're in the middle of the wilderness. You need surgery and you tell me and you tell the doctor, guess what? I'm performing this surgery on my own. I don't need you. I'm walking out of the hospital. I'm going to go in the desert. Now, maybe the doctor would try to stop you and do other things. But if you go in that desert by yourself, don't tell the doctor where you are. You take a scalpel out in the desert by yourself. You don't get to call the doctor and say, hey, I'm in the middle of the desert performing surgery. I'm going to be my own anesthesiologist. I'm doing all of this. How do you do this? Because they're not going to tell you. It's the same thing here. You're saying that you do not want to be represented by an attorney. You want to represent yourself. So that motion, that indictment, I'm not to tell you anything about what that indictment is. The state is not to tell you, oh, this is what this indictment means. This is the range of punishment. Those are things that you're supposed to do. Do you understand?
I still don't understand.
All right. So just have a seat. This is what's going to end up happening. You're going to have an attorney. That attorney is going to come over to the court right now. You're going to speak to that attorney. After you speak to that attorney, we're going to go forward. Ms. Ferguson, can you call manage to sign counsel and let them know that we need an attorney over here? And that attorney will talk to you. That attorney will tell you what that indictment means. That attorney will tell you the range of punishment. Do you understand?
I still don't understand.
All right. Well, I don't know how I can further make you understand.
Are we on the record?
Yeah. All right, Norma, get someone from manage to sign counsel here, please. All right, just have a seat and we're going to have an attorney come down. All right.
I would like to ask some questions on the record, if I may, while I have your time here.
Oh, no. Let me just tell you, you'll have my time till 5 o'clock because that's how long we're here. What is going to end up happening is an attorney from manage to sign counsel is going to come down. Do you understand?
I do not understand because I don't feel like I am needing an attorney because I'm here to represent myself as the flesh and breathing man, Hector Casanova Jr.
Sovereign citizens often refuse to admit that they understand anything because they take the word understand literally, interpreting it to mean stand under or be subordinate to someone or something. This tactic is part of a broader strategy to reject the court's jurisdiction. Sovereign citizens often engage in various linguistic tricks in an attempt to avoid acknowledging the court's authority over them. By refusing to say they understand, they believe they are avoiding any admission that could be construed as accepting the court's power.
Let's see. All right. So let the record of the court show that I, Hector Casanova Jr.
Stop.
Sorry.
All right, we're on the record. So what did you want the record to reflect?
So let the record of the court show that I, Hector Casanova Jr., the accused in this criminal action, has asked the court to divulge the nature and cause of the accusation upon the authority of the Sixth Amendment, and that this court has failed in its duty to inform me of the nature and cause of this action. Furthermore,
let me stop you. Mr. Casanova, let me ask you a question. Have you been given a copy of the indictment?
I believe so, yeah.
All right, so let the record reflect that Mr. Casanova has been given the copy of the indictment, and the copy of the indictment, it tells him what he is charged with. You may continue.
Now, these charges, are they civil? Is this a civil charge or a criminal charge?
All right, that is something that if you had an attorney to represent you, they would be able to tell you. What the court can tell you is that you are in a felony court and this is a criminal court.
Okay. So, this being a criminal, let the record of the court show that the action against me is criminal action. My following question would be, the Constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under the admiralty or military tribunal. In which of these two jurisdictions does this court intend to try me?
All right, so this is what is going to happen, Mr. Casanova. Someone from Managed Assigned Counsel is going to come over and you can speak with them or not speak with them. But the questions that you are asking the court are not, some of them are not in any shape, form, or fashion related to the fact that you're in a criminal district court. Do you understand?
I do not understand.
Okay.
But I don't think you'll be violating your oath of office if you did your duty under the Constitution. I am not seeking legal advice. What I want to know is legal intent. I have the right to appear as myself in my own person without a licensed attorney. In order to intelligently defend myself, I need to know the jurisdiction this court is operating under. Let's see. So therefore, will you please answer the question so that way this court is properly identified?
All right, you're in the 187 District Court. It's a criminal court. You're on the 4th floor.
Thank you. This Constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under
all right, I'm going to counsel. I'm sorry, Mr. Casanova, in the human flesh. I'm going to stop you right there.
Sovereign citizens often make the false claim that criminal courts must be either admiralty or common law courts. Admiralty, or maritime law, deals with matters specifically related to the seas, navigation, and international waters. Sovereign citizens misinterpret admiralty law, often claiming that courts operate under it when they perceive themselves as being commoditized or commercialized. To them, being held accountable for actions under state or federal law resembles being judged as a vessel, and they falsely assert that this equates to admiralty jurisdiction. Common law traditionally refers to case law or judicially created law based on precedents. Sovereign citizens often refer to common law as an older form of the people's law based on natural rights, and they shouldn't be held accountable for statutory laws, which are laws created by state legislatures. This misunderstanding makes them claim that only a common law court has legitimate authority over them, ignoring the fact that modern U.S. courts operate under a mix of statutory and common law.
Okay. What is going to end up happening, I want you to hear me clearly. An attorney is coming over for Managed Assigned Counsel, period. That's it. So have a seat. Managed Assigned Counsel will come over. Do you understand? Yes or no?
I do not understand.
All right. Do you understand what it means to take a seat?
I do understand.
All right, so take a seat. Thank you.
Inform him that I'm here, to help him in whatever he needs help with. He's going to consider what help he thinks he might need from me, and I know he wants to put something on the record.
Okay. All right. And so you'll be appointed as standby counsel then?
I've kind of explained my role and what that means and how I can help him with something as simple as e-filing or that type of thing. So.
All right. All right. So Mr. Casanova, Mr. Bonk is going to be your standby counsel. And that's someone that if you have questions, you can ask him legal questions or what you may have.
Thank you for your consideration.
All right. And he informed me you wanted to place something on the record?
Yes, for the record, I wanted to make it known that I'm here on special appearance under threat, duress, and coercion.
All right. Who threatened or coerced you to come to court?
The county of Bear, Texas.
How so?
Well, if I don't come here, then warrants will be placed, which I will be kidnapped and held hostage, and I do not want that. So that's why I'm here under special appearance to clarify any misunderstandings and to let it be known where I stand on the record.
Okay. Is there anything else?
I said everything that needed to be said.
Okay. All right. So what we're going to do is we're going to recall your case in 1 month. It's going to be a discovery setting. So that's to make sure that you have all the information that the state has concerning your case. Do you understand?
I do understand.
All right, Ms. Ferguson, if I can have a 30-day reset for Mr. Casanova. And after you receive all the discovery, then the next setting is going to be a plea deadline date. The state will tender an offer to you at the next setting. And then I'll give you your plea deadline date, and you can accept the state's offer or come to an agreement or not. If you're unable to come to an agreement at that time, it'll be scheduled for jury trial.
Thank you, Ms. Boyd.
You're welcome. Any other questions?
I have no further questions.
All right. All right.
I appreciate your time.
All right. You're welcome. And thank you for dressing appropriately for court. What date, Ms. Ferguson? All right. Once you sign the reset form, you'll be excused.
All comments, viewpoints, interpretations, and insights expressed in this video are for education and entertainment purposes. All individuals featured in the video are to be presumed innocent until proven guilty in a court of law. Please do not attempt to contact, locate, or engage with any individuals featured in the video.